Good afternoon, everyone, and welcome. I am really excited today to be talking about uh, a really pressing and complex topic, which is what should we expect over the next few years about privacy in the Trump administration, part two. And with me, I have some really great experts. Omer Tene of Goodwin Procter, longtime privacy expert, previously at the IAPP, and Amie Stepanovich, who is at the Future of Privacy Forum, a great think tank that is looking at all sorts of privacy issues across the board. And so I'm really excited to talk to you both today about this topic. I am a law professor at GW Law School. I've been specializing in privacy for 25 years now, which is shocking how fast it goes. And I'm really interested in this issue. I have a new book coming out next year called On Privacy and Technology. And I'm kind of looking at the last 25 years of the development of how privacy has been affected by technology and what the law can do to keep up with changing technology. And so I think this topic is very much related to that book, which is, we're looking ahead into the future rather than backwards. We're looking forwards to what is going to be the impact of this administration on privacy. And I think that, this question always comes up every time there's a change in administration. But what makes it, I think, particularly challenging this time, or the pressing question this time, is that this administration has some, I think, more radical views about government, about regulation, about the scope of agency power, and a lot of other things that I think are more extreme than most other administrations, whether left or right administration. So there's a chance that we could see some pretty radical developments. And everything is on the table. Things that you wouldn't ordinarily think would be on the table are on the table. So to start, I'd like to start with the FTC, which is the agency that is the biggest privacy enforcer here in the United States. And we already see that Trump wants to replace the commissioner, the chair of the FTC, the commissioner who is the chair. Right now it's Lina Khan. And he wants to replace her with another commissioner, a Republican commissioner, Andrew Ferguson. So that is on the table. The FTC is in the middle of a rulemaking. It's been a long rulemaking because their rulemaking process is a very onerous and long one. And they're looking to come out with a surveillance rule, which is now, I guess, in doubt. So I'm wondering, and I'll just throw it out broadly, and then we can go into specifics. What do you think the FTC is? What are we likely to see out of the FTC when it comes to privacy enforcement cases over the next few years?
I'll jump in really quickly on this because I actually think this is one agency that we have some interesting insight into, because Ben Brody at Punchbowl got a hold of the memo that current commissioner, soon to be chairman, Andrew Ferguson wrote, pitching himself as chair of the FTC. And so we have some insight into how he wants to look at that agency, his priorities, what he would be trying to do as chair, including the very first item on that is reversing the current chairperson's quote unquote anti-business agenda, Lina Khan's anti-business agenda. Now that stops because the second place is to hold big tech accountable and stop censorship. So what I think we are likely to see is a deprioritization of some of the more progressive privacy cases, enforcement actions from the FTC, and a lot of different areas. However, continued scrutiny of quote unquote big tech companies, both in terms of antitrust, but as well as privacy. And so it's likely we might see a split in how the FTC handles cases in those two different areas. Um, and I think that's very interesting and something we can look out for.
Omer, do you have any thoughts on this?
Yeah, certainly. First of all, Dan, thanks for hosting us here, and it's a pleasure to talk with you always. You started by saying that the next 4 years will feature a radical agenda. I think, radical is kind of in the eye of the beholder, because obviously the people are going to be in power viewed the previous administration, including the FTC, as a manifestation of a radical agenda. And I think anyway, it's unfortunate, kind of big picture for our politics that we view each other as radicals. And more specifically for this agency, which has always been bipartisan by design, and has really been fairly successful, I would say, over its history in steering clear of kind of the really hot button political issues. The memo or the page that Amie alluded to, that allegedly came from Commissioner Ferguson trying to promote his candidacy, is sort of phrased in very fiery terms. And I think it's clear that the next FTC will be starkly different from what we've seen over the past few years. Like Amie said, there is a line item there that says that Chair Ferguson now will reverse the anti-business agenda, but at the same time crack down on big tech, specifically in the context of speech and censorship. I think, some of the Republicans criticized Khan's attempt to expand FTC authority to this area of bias and discrimination, civil rights, as it's called in this memo. Well, actually, I'm not sure he used the word woke agenda, but that's what it's colloquially referred as. The memo actually does use the words trans agenda, whatever that means. So there's been a lot of criticism about that, but then if you try to implement a policy of kind of curtailing big tech's censorship of speech, I think that too would push kind of the envelope on the FTC's traditional authority, which is primarily against deceptive and unfair trade practices, and not so clear that this line of sort of limiting censorship even belongs there. So I'll stop with this.
Yeah, I think that's really interesting, and I think it is going to potentially be more radical, because I think that for a long time, the FTC has been bipartisan, and from administration to administration, you kind of see it being more aggressive a little bit, or kind of going to more narrow types of holdings. So I think during the Bush administration, the FTC focused a lot on cybersecurity enforcement. It was, I think, more conservative about using unfairness as a basis. And then during the Obama administration, it became more aggressive. It used unfairness. It went after it put forth more theories. And then during Trump, the first Trump administration, pulled back a little bit. And now during the Biden administration, it's put its foot on the gas. But I think throughout, though, it's been pretty bipartisan. A lot of except for a few cases, a lot of the cases on privacy have a consensus of most of the commissioners. And it's, I think, held a pretty steady pace. It hasn't really broken with precedent. And generally, it hasn't done many cases that would be like outlandish or rock the boat. There are very few enforcement cases where I think, one could look at them and say, oh my gosh, like that is so out of left field, or it's so uncalled for how, the FTC is pushing things. In most cases, they're settlements, so the companies actually are agreeing to the resolution of the case. But now I think, all bets are off. I mean, the agenda that, could be there, things the FTC has never really done before. It's unclear if kind of what the status of the existing enforcement is that going to continue, or is a statement going to be made like, hey, we're going to kind of really change the entire philosophy and ethos of the FTC and change the entire enforcement philosophy, which I think has generally been pretty stable over time, where the FTC has made it pretty clear it's going to follow its previous cases, and it's not kind of taking a radical new direction. So I think when it has put its foot on the gas or pulled back on the gas, it's been more subtle changes rather than dramatic changes. Although I think that I think this administration views that its mandate is more radical. It wants to, radically, change how things are regulated. So yeah, I think we'll see a shift in regulatory priorities that's a very different shift. And the other thing I also wonder about is, what about the courts? Because we are now in a landscape where the courts are increasingly less. Increasingly more hostile to agency power. And now, in light of the reversal of Chevron, in light of the fact that anyone can run off to the Fifth Circuit, where I think there's never been an agency regulation they like. There's never an agency they like. I mean, they are radically out there, and so if you run to the Fifth. And you push, back on the FTC's power, could the FTC lose power in the courts? And I could easily see, the FTC decides, hey, we're going to go after, social media companies that Trump doesn't like and then you'll see those companies, run over to Texas and say, First Amendment violation, and the FTC doesn't have the power to enforce against privacy, and who knows what could happen there? Do you have a sense of, what might, would things change with the FTC in court? Could the FTC kind of run out of luck and get its powers, like get a real curtailment of its powers?
Dan, before responding to the question, and actually let Amie respond first, kind of to keep it in the same order, I just wanted to relate to a couple of issues that you just raised, if I may. So first of all, again, you invoke, this notion of a radical agenda going forward, but I do think we've kind of been in a radical mindset for a few years now, and I'm not passing judgment, about either side, but I think it's really clear that the conservatives view the current FTC, the outgoing FTC, as pursuing and implementing a radical agenda. And in fact, you mentioned earlier the rulemaking about consumer surveillance, right? So just calling that consumer surveillance seemed, kind of pejorative. I think Commissioner Holyoke mentioned it was demonizing an entire industry, the ad tech industry specifically. And by the way, this was kind of from the last round, but you mentioned it, and I think it's really clear that that's over. I don't expect that to advance at all. in terms of kind of the spectrum between deceptive and unfair trade practices, which you alluded to, kind of when the FTC is more activist, it tries to enforce more on the unfairness side, and when it's less activist, it sticks to deceptive. I think that's, pretty clear. So one would expect this FTC to focus more on deception than unfairness. However, as we said earlier, this notion of limiting big tech access, and particularly in the context of censoring speech, that doesn't fit in deception. Maybe it could work through the antitrust authority, although it's not really, necessarily an issue of market power. So I think you're back to unfairness. So I think it remains to be seen whether this agency will kind of stick more to deceptive or not. The last thing I wanted to mention, and again, I missed this earlier, but very important for us, one of the issues that Commissioner Ferguson raised in that letter was that he wants to end the FTC's attempt to become an AI regulator. I think that's very important, going forward, and I'm sure we'll talk a lot about AI, but just wanted to mention that. And I wonder if he's kind of already regretting that he put it on paper, because now he will become the chair and maybe he would want to be an AI regulator.
Yeah. So I want to switch back on one thing real quickly, Omer, that you said. I mean, you might say that Khan is radical on some things like antitrust. Quite I don't think calling it surveillance is like this horrible insult. I mean, what else is it? It is kind of surveillance. Now you could say it's bad surveillance, but it's sort of like what is it other than surveillance? It just, you might say I don't like surveillance, but that's what it is. But what has Khan done? This particular FTC done? Let's put the rule aside. In enforcement that you think would be like radical, that would be something that was because a lot of people, oh my gosh, he's so radical, and maybe that's the things that were said, but like I'm looking at what's done, and I'm looking for what FTC enforcement, it's like whoa, that is big break from the past. They're like radical change that would give warrant to this both-sided.
I don't want to get into it, Dan, because I wasn't saying myself that it's radical, and I wasn't using this, adjective for the next FTC either. And in fact, I kind of regret that it's become such a big part of the discussion. I think it's clear that some of Khan's kind of agenda was criticized by conservatives, and they chose to call it radical. Their words, not mine. And I was just alluding to that this kind of cuts both ways. On consumer surveillance, personally, I wouldn't call it that. I would call it data practices, whatever, data brokers even. But I do think surveillance kind of already prejudges this to some extent. But English isn't my first language, so maybe I'm just misunderstanding.
Amie, how do you weigh in on this?
Sure. I think the question of limiting FTC authority is interesting. There was a comment in the chat about the FTC's record in court the last few years, and I do think we have seen a few of the FTC's actions in the antitrust space, not necessarily in the privacy space, get knocked back as beyond the scope of the FTC's authority and challenged somewhat successfully. So we've already seen an FTC that in at least some instances is pushing the boundaries of their authority beyond what the courts might deem appropriate. Some of the things that we're seeing in the memo, were it to be an accurate reflection from Commissioner Ferguson, or an accurate reflection of the priorities for the next 4 years, do also seem to push the boundaries of the FTC's authority, including, for instance, and I want to pull out, so I'm quoting properly, actually limiting the independence of the FTC as a quote unquote so-called independent agency itself. So actually incorporating more of the administration's views for an agency that has traditionally been very independent, has jealously and, in my opinion, necessarily guarded that independence, and having that encroached upon perhaps a little bit. So there is a lot of potential, I think, for the FTC to be continually brought into court. We've already seen that happen have some of their authority knocked back, and in some of these really controversial cases, I think that they could lose authority that could have been deployed in other ways appropriately, and that in the future might be something that isn't pursued because it's cast doubt is cast upon it by activity of the next 4 years. So that, I think, is absolutely something that we're going to see. The one thing I want to flag, Paul Gallant in his newsletter flagged 4 current and then an amorphous series of actions that are currently underway with major tech companies. And as I mentioned in my first remarks, Ferguson does seem to be very in line with the current FTC, specifically in terms of antitrust enforcement against quote unquote big tech. And so those cases, those ongoing actions, could see just continuation of what is currently happening, even while we're seeing kind of a pullback in those other areas. And one thing to note here in particular is one of those bullet points was, and I'm quoting again, stop abusing FTC enforcement authorities as a substitute for comprehensive federal privacy legislation. And so in particular, I think we're going to see a pullback on those privacy cases in exchange for potentially more in this quote unquote big tech antitrust movement, and devoting more resources in that area.
Yeah, you mentioned the federal privacy legislation, an issue I want to get to, but before I'd love to just shift to another agency, HHS, which enforces HIPAA. And there are some challenges now that are occurring in the Fifth Circuit, which, it sort of, they're filed there deliberately because the Fifth Circuit typically has, in almost every case I read, it's rare that they ever, side with the agency. Maybe every now and then, but they're much more skeptical of agency regulation, much less deferential, even prior to the demise of Chevron. On the table is the reproductive health rule of HIPAA. Some say even HIPAA could be in jeopardy. And I'm wondering what your thoughts are on what we're likely to see out of HIPAA enforcement and HIPAA cases over the next few years. Are we going to see, there used to be talk about, expanding the HIPAA rule, making HIPAA address more types of data that it hadn't addressed, updating the HIPAA rule, strengthening it. I think those things are probably off the table now, but I'm curious what your thoughts are on what's HIPAA going to look like.
We've definitely seen HHS take actions over the last few years, specifically to protect some of the potential obtaining and using data in regard to reproductive enforcement actions. Some of the laws that were passed in the wake of Roe v. Wade getting shut down. One thing that I think we're going to see and I think it's highly likely that we see some of those actions rolled back. What we're going to need to see is actually people getting individually more educated and more empowered to understand the exact, very complicated and nuanced rules and regulations, both at the HIPAA level as well as in their state levels, so that they know where their data could go, what health restrictions they're acting under, what happens if they are seeking reproductive or other healthcare in another state, what people can get access to. Believe what we'll see is a rollback of some of those federal protections, which means it's going to be significantly more important that people are aware of what's happening at the state level. And at that level, I think we've seen some of the Democratic attorneys general and governors already voicing some preference for actually extending protections at the state level in order to make up for what might be lost at the federal level. So regardless of that, I think the whole space is going to get a lot more complicated. There's going to be fewer general protections available, and people are going to have to be that much more vigilant in figuring out what are the rules that apply in their situation and what that means for what they can or should be doing in order to protect themselves.
Omer, do you have any thoughts on HIPAA?
Yeah, look, I don't know about HIPAA enforcement specifically. We have seen, the case in Texas already this past year, I think, where the court shut down basically the HHS OCR rules, rather, in the context of online trackers and how they interact with PHI. The HHS secretary is actually a Democrat, so I'm not sure how that will play. But I totally agree with Amie that, everything we're about to talk about and discuss, and specifically you mentioned the federal legislation, interacts very closely with the states because it's one ecosystem and there's a lot of feedback. And I do think that we are about to see the states really double down on protecting consumer health information, particularly reproductive rights, but that becomes a bigger kind of issue if you look at Washington's My Health, My Data Act, Nevada's, Minnesota, and we're about to see, I think, a lot more of that. So even if, the federal regulators step back, you should definitely expect to see the state step up.
Any thoughts on cybersecurity? What is likely to happen both in healthcare cyber as well as cyber generally? Do we see any changes that you think might be on the horizon in terms of policy there?
So I think even though we definitely know the healthcare sector is a huge target for cybersecurity, for ransomware attacks, for data breaches, and we actually haven't seen even the current administration really invest heavily in protections in that area. We've also seen some focus on healthcare cybersecurity by Brett Guthrie, who's set to be the chairman for the House Energy and Commerce Committee next year. But even in his case, he's actually emphasized that he doesn't want mandates for hospitals. And so more in that best practices, partnerships with government, self-regulatory space. So what remains to be seen is we've seen this kind of division in how the Republican platform and how President-elect Trump's comments have treated cybersecurity, where it has been generally in favor of deregulation, except there are comments that have been in favor of cybersecurity mandates in the infrastructure space. So depending on if they're going to come and look at the healthcare sector as infrastructure, could depend on whether or not they prioritize any actions in that area. My guess is going to be no. But we could see some movement, and if we do see movement, they could actually surpass what the current administration has done in this space.
Any thoughts, Omer, on this?
Yeah, I would just connect it back to our FTC discussion and say that I hope that at least on this issue, we can have consensus and, sort of a unified front from the FTC, which of course also has been an important promoter of cybersecurity. And I think most of the enforcement actions are still more security than privacy. And that doesn't, seem to me to be an issue of any partisan kind of strife. So hopefully that will at least be a consensus agenda, and obviously an incredibly important issue.
Yeah, I mean, not to keep picking on you and disagreeing, I think generally cyber is a consensus security, and the healthcare industry has been just battered by ransomware attacks. But that then leads to something where there might not be as a big consensus, which is crypto. Crypto plays a very big role in ransomware attacks, and I increasingly think that really to address that problem, I think you have to start looking at regulation of crypto. I'm not sure you can really just stamp out ransomware attacks without doing anything on crypto and just say we're going to totally let crypto go wild, and then that we can just deal with data security with the traditional measures, which is just tell people to get better passwords, don't fall for phishing. So I kind of think it's still going to get worse and worse and worse until we dry it up at the source, which is the financial incentive for the security attacks on the healthcare industry. And so I'm not as optimistic that we're going to see or we might see consensus like, hey, we don't like these attacks. I wonder if the lack of consensus over what needs to be done to address them, it will lead to just kind of letting this problem, it's going to continue, is my prediction, because I don't think the government really, this particular government really wants to do any kind of regulation, strong regulation of crypto. But let's go to the federal privacy law issue. This is another issue that Omer and I have strongly disagreed on. There have been, over the last few years, attempts to pass a comprehensive federal privacy law because of all the state laws. These laws are, I think, both of the versions of the law that were proposed. They're two different laws, but they were, they had a lot of similarities, and they were actually not so bad. They, in a lot of cases, they were stronger than the state laws being passed, which I think a lot of the state laws are like incredibly weak. Like weaker than watered down broth, but the federal law was not bad, not where the GDPR is, but and ultimately these efforts failed. Preemption became a really big issue. I was not a fan of the laws. I didn't think it was worth the price. Omer thought it was worth the price. Now what? Now we're in a different administration, a different Congress. What do you think the likelihood of a comprehensive federal privacy law is going to be, and do you think that and what do you think that law might look like if it were to pass?
Yeah, maybe I'll start because it seems like you're looking at me. And I think, the bottom line is that I'd say I hope that you won't regret not having paid the price for that law, which had some degree of consensus. So there were a couple of drafts, the APRA and the ADPPA. The last one was actually a three corners bill, so it had the support, bicameral and bipartisan support, including the support of the Republicans in both chambers, Roger Wicker, Senate Commerce, and CMR in House Energy and Commerce. And that bill had a private right of action. It had some preemption, but not complete. There were a fair amount of exemptions. And importantly, substantively, it had a very strong data minimization requirement and strong provisions on civil rights. I think if we do see a bill come out of the next Congress, and of course, you have to remember that now not just the administration, but also both chambers are controlled by Republicans. Ted Cruz will now be the chair of Senate Commerce. And like Amie mentioned, Brett Guthrie will replace CMR, who retired. On the House side, I think it's going to be a very different type of bill. And I think it's pretty clear that it won't have a private right of action at all. I think it will have very strong preemption because that's what the industry is basically clamoring for. I don't think it'll have data minimization, certainly not in the sense that it existed, maybe in a more watered down version like you see in the Texas privacy law. So it's more tied to purpose there than kind of an outright minimization provision. And obviously, it won't have the quote unquote woke bias and discrimination and kind of civil rights provision. So, I think that could come out in next Congress because all arrows are pointing in the same direction. Maybe it won't rise to kind of the level of priority as some of the other issues they'll be dealing with. So maybe we won't see it, but if we do see a law, I think that's what it's going to look like. Before I close, I'll just say that, of course, if well, you know what? I'll stop here. Let's let Amie weigh in. I don't want to overplay my hand.
Omer, you can play as many hands as you want to play. I think there's a few points here, and I agree. I think if you look back at APRA, which had the support of the civil rights community, of many people in the privacy advocacy community, it just broadly had a lot of people supporting that bill. It generally, however, did not have the support of many people, specifically in California. Regulators, public policy groups, advocacy groups in California specifically stood against that because of some of the preemption provisions, ultimately didn't pass. And now we're looking at a serious spate of leaders who have taken broadly a anti-regulatory stance toward privacy, toward security, toward AI, but have talked positively. Both Brett Guthrie and Ted Cruz have spoken positively about the potential to pass a privacy law. In particular, Ted Cruz, I think, is looking at the Texas privacy law that passed Texas might not only be the Lone Star state, it might be the Lodestar state in the next years for privacy legislation, and a model that might end up getting picked up considering his position with the Senate Commerce Committee. And I think it's going to be significantly, as Omer said, I agree, probably missing the civil rights provisions, very much stronger preemption. I can't imagine a private right of action, because if you're going to get away with passing a privacy law with a deregulatory preference, what you want to do is say, we're actually wiping the board of the state privacy laws and passing them with a single standard. And that's how you make it to actually taking away regulation rather than just issuing new regulation. More likely then, though, that I see a comprehensive privacy law is potentially a kids' privacy law. There's a lot of support for that. Even Ted Cruz has been quoted saying that he's not sure that it's exactly ripe for the consideration of a comprehensive privacy law, but that the focus could be back on kids' privacy. And so there was there were a few proposals this year, most recently one that Elon Musk weighed in on and offered some edits to, and has had some support. And I think we're very likely to see that resurface next year, and it could get quite a lot of attention. So adding that, in addition to potential for comprehensive privacy, which I'm not sure that we haven't seen it in 30 years. I'm not sure we're going to see it in the next 4. But I think that there is some support for that. I think there might be higher support for a specific kids' privacy bill, and that will be an area to watch much more closely.
Yeah, most definitely. I think that I think there is going to be a good chance there'll be a kids' privacy bill. Whether those are very tricky with the First Amendment, and whether it would survive. How it's going to do age gating, I think is really tricky. There's a lot of pitfalls. So maybe something will happen. Will it survive in the courts remains to be seen. On the federal level, I mean, I still think that the preemption isn't worth the price. And I say that even though the law is it was decent, but I still think even the GDPR is not getting the job done for privacy. Preemption is very tricky because just as a political problem is there are a lot of representatives from states that have a lot of market power, like California, and why do they want to tie their hands just so that states like Alabama get a privacy law? They might we don't want to give up our power to get a federal law when we have the control of the legislative agenda, which kind of brings the kind of doubling down of the states in light of the civil liberties, civil rights agenda of the administration. So that I think that we might see more activity in the states, and would those states want to tie their legislative hands in the future to say, hey, we can't pass laws dealing with privacy. And the one challenge is privacy is such a sprawling concept. So when you say a comprehensive privacy law, what does that mean? The state laws are broad privacy laws. Are they comprehensive privacy laws? I would say no, because they omit a lot of issues with privacy that, a lot of them exempt publicly available information, which I think has privacy implications. They will exempt government entities and nonprofits, and only cover certain larger for-profit entities. They really focus a lot on data transfer, sharing and selling of data, but a lot of them don't regulate first-party uses that much. So they're much more narrow, I think, than when we look at what the GDPR does. I think it's unfortunate in the early days of the California law, everyone's it's the California's GDPR, and California, of course, ate that up like, yay, we're just as great as the Europeans. And I kind of think no, it's not the GDPR. It's much more narrow. It's much more restrictive. It's not really comprehensive. It's broader than most U.S. privacy laws. So if you take the Texas law, which is kind of built on a model that's like a shadow of California, it's kind of like the Virginia model, but with very, very, very restrictive in terms of what it covers. Actually, enforcement's been pretty strong in Texas. The enforcement's good, but the law, I would say, would be a lot would be left out of the federal standard. Then the question, does that preempt other states from enacting health privacy laws? Does it preempt them from biometric privacy laws? Is it going to what's the impact going to be? Will it prevent states from enacting children's privacy laws? I wonder if the states are going to be interested in that, because this goes to the Omer point of, states might very well double down, a point that I agree with on Omer. Point of agreement. I think the opportunity for states to double down and the incentive for states to double down might be very strong, especially states like California or New York or Massachusetts. That New York and Massachusetts haven't really weighed in here, but I think they're going to. What will happen? And the states might say, hey, we see increasing differences in policy from the federal government. And we might want to, and other states, and especially with healthcare, privacy, reproductive healthcare, people traveling to states like California to get abortions, they already are, starting to legislate there, and I think we might see more legislation to come as we get into these big battles over rights and data that implicates rights. So I think the states are going to play a big role over the next 4 years, or might play a big role. Actually, I have an op-ed saying that states really should step up and start passing things and can really start addressing issues of government access to data at the state level, and can do things that could be pretty powerful. And I think that's likely to happen. So would they vote to tie their own hands, or are there enough votes in Congress to get something through on that basis. I don't know. There weren't before, when the law was much more civil liberty, civil rights friendly, like this last bill. So I think we're going to see maybe even less support this time around. So I'm not sure we'll get that kind of compromise through Congress, but we'll see. But I'm curious, generally, what are your thoughts on what is on the horizon state-wise, and what states might be doing for privacy? Omer, I think, rightly says it's kind of an ecosystem. There's a push and pull, like what happens at the federal level affects what states do. When some of these bills were looking like they had some legs, we saw a little bit of a pause in the state legislation. The states kind of, took their, we didn't see many, and then suddenly they ramped back up when those bills kind of became very unlikely. So, I wonder what you think is likely to happen at the states.
So I'll put in a quick plug. Jordan Francis on the FPF team recently published a report. It's on our website called Anatomy of State Privacy Law. I believe it's excellent in analyzing what we're calling the two different approaches, kind of the California approach and model, which really only exists in California. And then we have the Washington model, so-called because that model was first formulated and introduced in Washington, ultimately didn't pass, but has stood for the model of the 17 other comprehensive data privacy laws we see in the states so far. I do think we are likely to see that general model continue to proliferate over the next several years, although with key distinctions. Several of those laws, as they've gotten passed, have added things or altered the scope or the protections available in some way. And one of the trends that we've seen is actually something Omer brought up, which is data minimization and an increase in the change in form, as well as an increase in protections around data minimization. So another report that we put out talked about how previously a lot of those laws had, again, what my colleague Jordan Francis called procedural data minimization, meaning you mostly had to tell individuals what the purposes for the data you were collecting were going to be, and then you could only use data as reasonably necessary to fulfill those purposes. What we're now seeing is a growth in what he would call substantive data minimization, which means the use of data has to be tied to the service being requested by the individual, not necessarily what is disclosed. So what that all means in practice, I'm not entirely sure yet. FPF might be putting out something soon that explores some of the questions that we have about how that might be implemented and what it might mean. But it will be interesting to see how now different states iterate on that data minimization idea going forward, and what else they might want to include, particularly where we started around reproductive privacy, if we're going to see more protections in that area coming out of democratic states in response to what we might see at the federal level from this administration on reproductive health data.
Yeah, two quick points on that. I think the data minimization standard, Maryland is the law, I believe, the one state law that had recently enacted that, and we'll see how much more rigorous that is than the traditional data minimization standards in these laws, which is kind of weak because it really is. It's a very easy thing for companies to say, we'll just cook up a purpose that we can make the data related to. Maryland actually could put some harder limits on that. We'll see how that looks in enforcement, but that could be it's a pretty significant change in regulation and could shift the amount of data collected. And the other point is on the health privacy. Washington, even though it failed to pass its privacy law, did pass a health privacy law called My Health, My Data Act. And that law has a very broad definition of health data and very powerful data deletion rights that or even hard to imagine. It actually could be inconsistent with other things like litigation holds and other. It creates some big problems, and it has a private right of action, which has not been used that much yet. But we'll see how that plays out. But it's a pretty powerful law, and I think other states might be looking to do something similar over time. So we're seeing that on the horizon. Omer, do you have thoughts on the states?
Yeah, and just responding to a couple of earlier points, Dan, you seem to kind of present the GDPR as the gold standard, and I'm not sure it necessarily is or should be. Some would argue that it created a lot of red tape, but not much privacy on the ground. I think the biggest challenge with kind of the state-by-state ecosystem is that it creates a patchwork that is just a boon for lawyers. We're not complaining, but a real cost for businesses that are trying to understand what they need to do and figure out how to comply. It's just becoming more and more difficult now with 19 comprehensive state privacy laws plus Florida, which is a bit different because it only applies to large companies, and then a lot of these other sector-specific laws. So overall, you're looking at hundreds of laws on privacy and now enter AI in different states. With respect to states going forward, I think, if there is no federal preemption, we will see a lot of state activity. It's obviously been a frenzy for the past couple of years, and I think it will continue and maybe accelerate in certain vectors. One of them, as mentioned earlier, is health and consumer health, and particularly reproductive health privacy in blue states. Other issues, we mentioned kids. So we've already seen New York with a couple of kids privacy laws just this past year. The Age Appropriate Design Code Act, which Maryland now passed. California is still on hold in the courts, but will probably land at some point. AI is a big kind of issue that we're seeing state legislation, hundreds of bills on AI governance, AI transparency, and some other more niche kind of approaches or areas, namely California's SB 1047 on frontier models, AI safety for kind of the big models, which I think Elon Musk actually supported. That bill passed through the California legislature, but was vetoed by Governor Newsom. But it's expected to make another appearance. Also a focus on sensitive data in different states, on data brokers. I think those are the main issues that we expect to see more of.
Yeah, a lot there to unpack, and I do want to get to AI really briefly. On the GDPR being the gold standard, I would say, yeah, it's sort of the standard today. Do I think it is the answer to privacy? No, I agree. There's a lot of things in the GDPR that don't work, that are a lot of paperwork, but not really practice. You're really changing things in practice. I mean, I think ultimately there has to be a fundamental change in the way companies do business with regard to privacy, like a real change. And a lot of the laws don't really ask that much of companies other than to just, throw a little bit of money behind it, do some, bureaucratic things, produce documents, stand up, individual rights, which I don't think work very well. And then, and it's expensive, but ultimately too, if you look at most of the state laws, despite the differences, if you take a broader view back, they're really very similar, quite honestly. There's differences. They have slight, headaches because they define sensitive data a little differently. But, outside of Maryland, they're largely, I think, more similar than not. If you were classifying them as like on like an animal taxonomy, they'd all be like lions or tigers. They wouldn't be, like lions and elephants. So I think that, they're, but I think now we might start to see new, in the future, new directions from the states like Maryland, or the Vermont law that had a private right of action that other states might follow suit at some point. California is never done. Don't think we're over in California. We're going to see a lot more laws there, if there is no federal preemptive law, which I don't think there will be.
Earlier you said they're like weak broth. So
yeah.
I'm glad to hear there are lions and tigers.
Yeah, maybe I used the wrong analogy.
The truth is somewhere in the middle.
Mice and rats. But it's but yeah, that's true. Maybe bad analogy. The AI, really quickly. What do you think is on the horizon? At the federal level, we have the executive order, and we have a lot of stuff going on in the states. Obviously, I think there's a concern again of like, what about the patchwork problem? Are the state AI laws going to be more divergent than the privacy laws, which I think, the vast majority are kind of built on the Washington model, which is not that different than the California model. Different, but not a lot. But I wonder if the AI are going to be all over the place, how that's actually going to work, and what's going to happen to the executive order.
I mean, I think AI has been the most common thread that we have seen amongst leadership coming in next year is deregulating AI. We have heard that the executive order is going to be repealed. The two members of Congress, the chairs of the committees, both Guthrie and Cruz, have talked about, we want to take away any regulations on AI. We don't want to regulate on AI. That was part of the memo from soon-to-be Chair Ferguson that was put out. Don't regulate on AI. It's just a very common crosscut at the federal level, which actually means, I think, much like what we said about privacy, we're going to see an increase at the state level. This is going to be one of those things that I think we're definitely going to see a lot of action on. FPF has been playing a coordinating role for state lawmakers trying to learn more about AI. And I think that we are likely to see many of them try to take action. We already have Colorado with a comprehensive AI law that was passed this term. And I think that even though that they've said that they're going to come back and revisit it, that's going to provide a basis for other states to act in that area.
Yeah, I posted about this actually on the socials, kind of my predictions, and I called it a shift from DEI, so diversity, equity, and inclusion in AI, to DEI, defense, energy, and infrastructure. I think we can expect to see less regulation on, the blueprint for an AI Bill of Rights that came from the White House, so less regulation about AI, anti-bias and discrimination, and the greater focus on national security, competition with China, and specifically, I think the really bottleneck issues for AI growth and innovation, which are chips manufacturing and energy consumption. Of course, training these enormous models is incredibly energy intensive. And I think the US and other countries are trying to find ways to make that more efficient and palatable. So I think we're all in agreement on this, that we can expect less traditional DEI regulation from the feds, but like Amie said, that might well mean more of that from the states. And as I said earlier, there are kind of a few flavors. There isn't one model like in privacy, but there are a few flavors. There's Colorado with focus on consequential decision making. There are a few laws, California 2013, and others focus on transparency and a few other issues. So it's going to be an active front.
Thank you both. I think if there's a takeaway, I think one key takeaway, a point that you both have made, is there's this push and pull between federal and state, as well as world, right? The EU, a lot of the law in the EU is to some extent a response to and has big effects on the US regulations. A lot of the US regulation is adopting certain components of the GDPR, right, to delete sensitive data, the definition of personal data. We're seeing this influence. And I think that, the idea that if you don't do anything at the federal level, let's just get rid of the executive order, let's do nothing at the federal level, or let's just pass a really, really weak privacy law that doesn't really regulate, that's not really the end of the story. Because we have this push and pull. Like if the federal law is weak, we have the states try to step it up in different areas, either subject matter specific privacy laws like biometric privacy laws or health privacy laws where HIPAA doesn't regulate, or the state consumer privacy laws in the void left by the federal law. And the Europeans, the EU, the GDPR exerts a tremendous influence worldwide and on U.S. business. So, U.S. business can't just say, oh my gosh, there's no federal privacy law, we can breathe easy, or we get this really weak or no federal AI law, we don't have to do anything. There's still a lot of the big companies want to tap the EU markets. That's like, 400 million people. And, they're not going to just write the market off for, so I think you're going to have an influence there. Does the U.S. kind of take a lead, or does it just say, hey, we're going to keep in our kind of more light regulation touch and let the main drivers of the ideas and the concepts and the regulatory tools go to the EU and the states, where we're seeing that innovation. A lot of the innovations are from the states or the EU. Things like, not all of them work. Sensitive data, I don't think it works, but that's from the EU. We have the definition of personal data from there. We have the data breach notification from the states. All these things are coming out of these areas that are, I think, going to continue to drive that conversation, drive the regulatory conversation worldwide. Federal is not the last word, and I think we're going to see a lot of interesting developments over the course of the next year, in light of this new direction that we might see the federal government going in. Thank you both. We'll check back and see if our predictions hold true. Be curious to look back on this. Like we should rewatch this in a few years and see what we think. If we'll chuckle at how wrong we were, but we'll see. Thank you both. Really enjoyed chatting with you this afternoon.